Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
Good afternoon, everyone. My name is Evan Bradley, and I'm one of the 5 partners over here at Campbell Property Management. I'm also a licensed CAM, and I work very closely with some of our largest clients on the major issues facing their associations, especially on the HOA side. For those of you who may not be as familiar with Campbell as a company, we've been in business since 1953 here in South Florida, and we manage over 450 HOA and condominium association clients in Dade, Broward, Palm Beach, Martin, and St. Lucie counties, all up and down I-95 here in South Florida. We pride ourselves on our client retention and satisfaction rate. You can see that in our Google reviews that we're the highest rated South Florida management company, and we do renew about 98% of our contracts annually, even though they have 30-day cancellation clauses. We have a very important guest with us today. Our guest is Steve Rappaport. He's a partner in the firm of Sachs, and Caplan. I've had the pleasure of working with Steve for several years now, and he's very much in tune with condominium and HOA law. So, Steve, would you like to share a little bit about yourself and the firm?
Well, just appreciate being here, and it's always good to be with Campbell and with you to do these seminars. I've been with the firm since 2002. I'm a partner in the community association practice. I tend to serve as general counsel and on corporate compliance, document-related issues, elections, things of that sort. Pretty much your day-to-day general legal issues, and a lot of that includes architectural control and review responsibilities. So glad to be here and look forward to our discussion.
Great. Thanks, Steve. Just a reminder, this is for informational or purposes only. It is not meant to be legal advice. If you have questions about your specific community or your individual situation, please do reach out to your association's attorney, or if you don't have one, please do take Steve's contact information down. I'm sure he'd be happy to help. Please do take advantage of the Q&A that we have open today. We will try to address questions that are asked throughout the course, but keep in mind, try to keep it limited to the presentation material. Individual legal questions about your personal situation, we're not going to be able to get to today. So we have about 30 minutes set aside, so let's get started. What's on our agenda? We're going to talk about architectural review committees. We're going to talk about the authority of that committee, the association documents and rulemaking and how those things interact and how that impact what your committee and your association can do. There are some very important statutes, particularly on the HOA side now, that govern committee action and board action as it relates to architectural review. Steve will get into that. And then we'll talk a little bit about the actual committee meetings themselves, because it is very important how you actually operate that committee. So getting started, what is an architectural review committee and where do they get their authority, Steve?
Well, in general, the Architectural Review Committee, or it might be the Architectural Control Committee, Design Review, whatever your name is, it's generally going to be from your Declaration of Covenants. 90% of the time when we talk about that type of committee, we're talking about on the HOA side or in an HOA declaration. Condominiums, they can have architectural committees. It just seems like they don't tend to have them. It's usually at the board level. So we're going to talk a lot about HOA things, but really, as a starting point, I do want to say that for the condo people on the webinar, what we talk about in HOA world is really still good practices or really best practices from the condominium perspective. So if we talk HOA specific, do understand that while there might not be a specific statute in 718, your authority is still going to be derived from your documents, and there are still good practices that you want to put in place anyway, and you probably should follow the form that we talk about. But the bottom line is your authority for a committee is really going to be sourced in your declaration of condominium or declaration of covenants.
Okay. So, broadly, kind of what is the purpose and general authority that this committee has? We'll get into some specific questions in a minute, but
the general authority is if I, as an owner of my property, want to make changes to my property, the declaration may say that I have to get approval of the association, and what form and what procedures that entails is going to be entirely subject to your documents and your rules and regulations, which we'll get into in a little bit further. But the bottom line is the purpose of this committee, if you have one and if you have that authority in your documents, is to be able to control what types of things people can do in your association with their own property.
Right. And in general, the concept is we want to try to keep a harmonious appearance within our communities. Many of us bought into HOAs with the idea that we don't want to live next to the purple house with pink shutters, and we don't want the grass to be 4 feet high at our neighbor's house, because that obviously is going to affect our property value. So as much as we may not like the fact that we have to go through the architectural review committee, it does serve an important purpose, and it's the reason a lot of people do choose to live in an HOA, because you don't want to have unsightly properties, across the street or next door. So we did get some interesting questions posed to us in the registration, and thank you for those of you that submitted in advance. A kind of popular one was, can the architectural review committee require the project to be permitted or evidence of permits when they come up to the committee?
Yes, and we'll get into architectural guidelines and standards, I think, in a couple of slides, but I think you want to have that as part of your rules and regulations and part of your requirements, and even part of your application package is to have a place for them to submit copies of their permits. But yes, absolutely, if you have it in your documents and in your guidelines and rules, you absolutely can require, and we recommend that you require that a project be properly permitted.
Right. Another common question was, is there a time limit where if the committee has not ruled on a particular issue, is it automatically approved, automatically disapproved? What happens?
That's not governed by statute, so that's going to be something that's generally in your documents, and it's very common that there is something in the declaration that will say that the association has to act upon it within, say, 30 days. That's usually the common, sometimes maybe 60, but it's usually a 30-day time frame. What's interesting is sometimes you'll see a declaration say that if it's not acted upon within that 30 days, it's deemed to be approved. Other times I've seen it actually say it's deemed to be disapproved. So pay very close attention to what your documents call for. You can even possibly amend your documents to have the deemed disapproval language, that way you don't get caught in an automatic approval, and it puts the burden on the owner to make sure that they come to the table and get their approval within that 30-day time period.
Right. Yeah. So it's very important that if you're on that committee or you're on a board in an HOA in particular, and a condo, do understand what your documents specifically say about this. You don't want to get caught in a situation where something you really didn't want to see in the community got automatically approved. So this is another very common one. What can be done when the committee approves a project, but then the end result, either the owner or the contractor has taken, I'll say, some liberty with the original design and has now changed maybe the color scheme, the height, the whatever it might be.
Yeah, and look, it's an enforcement issue. So anything that you have in your toolbox to deal with the covenant enforcement is what you can do for this type of situation. It's a violation like any other violation. So you have a number of different remedies. You have the ability to fine or suspend if you have a fining committee and you go through the process of levying a fine or a suspension. But that doesn't always get the job done, because if you're talking about a $100 fine or even $100 a day fine up to $1,000, but it would cost the person $5,000 or $10,000 to redo the project, obviously they'd rather pay the fine than get the compliance done. So that fining isn't always the best remedy when it comes to architectural and maintenance issues. But you have the right to go to mediation, to go to arbitration if you're a condo, but mediation most likely as an HOA, and eventually possibly a lawsuit to compel compliance with the documents. But the question brings up the important point that you need to make sure that the application calls for specifics, and you need to make sure that whatever they apply for is very clearly specific in the application. So when you approve it, you are approving very specific set of instructions and specifications for what they're doing. Because if there's any vagueness or ambiguity, that's going to be set up for a clear lawsuit over, well, maybe they did build in accordance with their plans. If their plans were a little ambiguous, how do we know they didn't do what they were asking if it's not clear on the application? So we as associations have to make it very clear what we're actually approving, so they're on notice of what they have to do. And so we have a better case if we have to go after them in court afterwards.
Sure. So this one was also somewhat common. If the committee has decided on approving or perhaps disapproving something, can the board overrule their decision and decide that it is permissible or not?
It's a great question. I get that one all the time, and it's usually a maybe, again, depending on what your documents call for. So you could have a very good set of documents that provides an appeal process, and that answers your question. If the ARC comes back with a disapproval, but the documents may say that an aggrieved party may be able to appeal to the board within 30 days, and then it goes to the board would have the right to either overturn it or keep it the way the ARC wanted it to go. So your documents can actually call for an appeal process, which gives the board a second bite at the apple. If you don't have that, then it's going to be entirely dependent on how your architectural provision in your declaration is drafted. If it has language that basically says that the ARC is the final arbiter of all decisions, then I don't think the board's really going to have a bite at the apple, because if the documents are calling for the ARC as the official final decision, then it's their decision. But if it's open-ended, if it's vague, if it says that the association shall approve of any new construction, but then delegates the authority to the ARC, well, then you can have the argument that, hey, the ARC acted, but since the association is ultimately in control of what goes on, and since the association is governed by the board of directors, the board has control over that committee. So I think it really depends on how the wording is done. I think where you get into a problem is if the ARC approves something, the person relies upon that approval, starts building their project, and now the board comes in and says, oh, you know what? We don't like the decision of the ARC. We want you to go back and undo it. That's going to be a little bit tougher, because now that the person has the approval in writing, has the approval from the ARC, which they were required to get under the documents, and they acted in reliance upon that and actually started the project to their detriment, spent some money on it. I think that's going to be the harder fight to fight for the association.
Sure. Yeah, I agree 100%. Another, I mean, this is pervasive in our communities, not enough volunteers. So how, people were saying we have no volunteers. Can the board do this? We can only get one volunteer as a committee of one. Acceptable or reasonable? What are your thoughts there?
I don't love the idea of having one person. I mean, I guess in theory, because the board has the right to delegate authority and the committee could have the right to delegate authority, you could argue that. But the problem is, as we'll get into later, because this is an open committee, how do you really notice a meeting of one? I mean, I suppose you could notice a meeting of one person, and as long as there's a proper delegation of authority to that one person, then I suppose it's proper. But I don't love that. And I think you should at least strive to have a full committee of at least 3 people, maybe sometimes even up to 5. Do your best to try to get participation. I also like the idea of maybe having some alternates, because if you have a situation where somebody may be conflicted, you don't want to lock the same 3 people in. You might want to have a pool of people from your community if you're a large community, and then dip into that pool from time to time and vary it up a little bit. I think you really should strive for at least 3 and try to have as many people participating as possible.
Right. Yeah. So now moving into the documents and the rules, which you've alluded to a few times already. Why don't you explain to us a little bit about the difference between the association documents and association rules, and kind of the interplay between everything?
Yeah, so you've got your declaration of restrictions, or your declaration of condominium, if you're a condominium, and that's your most superior document. That's the covenant that's going to bind the use of the property. So that's the one. That's why it usually takes 2/3 or more to amend it. It's a membership vote. But it's your most superior document, and the one that's what we call clothed with the presumption of validity. What's in your declaration, unless it violates some law or is discriminatory, is gonna be upheld and enforceable no matter what. Now, your rules and regulations are great as well, and we love rules and regulations because 99.9% of the time they can be amended by the board. So we don't have to go to the members to amend our rules and regulations, but we need to be careful because our rules are governed by a reasonableness test. They're not deemed to be enforceable like a declaration provision, and they can't conflict with the declaration. So if you have something in your declaration that calls for a specific type of structure that's allowed, you can't vary your rules or your architectural guidelines to detract from that, because your declaration is going to control over any conflicting rules. But I will say this, most HOA declarations will give good rulemaking authority on architectural issues. Usually the HOA's architectural provision will actually say that the board has the right to adopt architectural guidelines or other rules or criteria. So as long as you have that delegation of authority in the declaration where you have that clear rulemaking authority and it refers to guidelines and specifications, then as long as you're not adopting any guidelines that are conflicting something else somewhere else in the declaration, you're fine to adopt these as rules and guidelines at the board level. But you need to make sure you have that delegation of authority from your declaration in the first place.
All right. So, how are rules created at the board level? Because it's a little different, I think, when you're talking about how it affects people's property. So.
Right. So, you have to obviously have a duly noticed and properly open board meeting, notice to the members. But the big key distinction between this and any other type of board meeting is normally you have a 48-hour posted notice for most board meetings. Slight difference for special assessments, that requires a 14-day notice. But the other meeting that requires a 14-day notice is a meeting where you're adopting rules that regulate the use of the individual lots or parcels. So the meeting where you're going to adopt any rules that deal with what people can do on their own property, that's going to need a 14-day notice. And that notice not only gets posted on the property, but it needs to be mailed out to all owners Or you can use email, but only if people consent to using emails for their notices. So that's, encourage you to do that if you can. But, you need, because this is something that's unique to what people can do with their property. That's why the legislature put in this extra notice requirement of the 14 days and making sure people are mailed it or emailed it, other than just posting it somewhere in the middle of the community.
Right. And I think you touched on this earlier, but I mean, ultimately, if someone makes a change that never went to the committee, let's just say they did work without any approvals at all, or they violated, the rules that were set up by the committee, how does that get enforced?
And it's the same process. So whether they didn't get approval at all and just built, or whether they got approval and thought they got approval for something and then changed it and did something not in accordance with what they were approved, you still have the ability to fine, suspend, go to mediation, go to a lawsuit. It's basically a covenant enforcement issue. So it's going to take it's a little bit of a process, but those are the remedies. Now, as an HOA, you may also have some remedies of self-help. So you may have something in your documents that says, if somebody builds not in accordance with the guidelines or standards, or not in accordance with their approval, then you may have some authority to go on the property, remove the violating structure, and charge them the costs as an assessment. So you want to look for your documents for that possibility. But that's kind of iffy, because I don't know that a lot of people are going to be okay with you coming onto their property and taking away a huge improvement. And I don't know if the association is going to necessarily really want to get involved in the business of something like that. So, but that is out there, and there is some case law that says that if you have that self-help right in your documents, that you do have to at least reasonably try to use it before going to court. So, when you have these types of violations, you really need to consult with your counsel as to what are our options, and whether if we have this self-help remedy, do we really need to exercise it? Can we go to court first? Do we try mediation? But again, it's all covenant enforcement. It's all something that you're going to have to get with your attorneys to figure out your remedies.
Right. So I think I hear the word grandfathered more about architecturals than anything else. So
Yep.
So if a resident had made an improvement, and then the board has come in now and said that particular type of improvement is now not allowed here, whatever that may be, is that old improvement grandfathered in, or if the board changes the rules, can they change the rules for owners who made changes prior to that?
Right. Now, if it's if you've put something on your property pre-existing the rule change, and it was in compliance with the documents beforehand, or at least didn't violate anything because you didn't have a provision or a rule in place when the person put that on their property, they're going to be protected. You can't come in after the fact and say, hey, you built this fence. We don't like wood fences anymore. You built this 15 years ago, so now we're going to force you to take it down. That you can't do. But what you can do is you adopt your new guideline and say, hey, moving forward, we're not going to allow wooden fences anymore. If you have a wooden fence, you're grandfathered, and we'll take a picture of it, make sure our records reflect who has the non-conforming fences, and you're protected. But when you go to replace your fence, or if a hurricane comes in and blows down your fence and you need to replace it, we now have a guideline in place that says that moving forward, you can't replace that with a non-conforming wooden fence anymore. So again, it's very important when you talk about grandfathering to know it's the violation itself and not the person or the property that's grandfathered. That person doesn't get to have the non-conforming fence in perpetuity. They get to have it as long as it's still standing. But if they have to replace it, if it gets blown down, they're going to have to comply with the new standard moving forward.
All right. So we could talk about rulemaking all day and probably do just a course on that. There's some new statutory requirements now, especially on the HOA side. So that's Florida Statute 720, that relate to what an architectural committee must do to make their actions effective. So do you want to get into that a little bit?
Yeah, there are a few new laws that came out this past July. One of them basically says that the architectural committee has to approve things in an equitable manner, I think is the language they use, which, first of all, it's not defined and it's kind of meaningless, but that was sort of the standard always. I mean, you've got language in the documents in the statute that already previously had said that an architectural committee can only make their approvals based on the objective and reasonable guidelines and criteria in the documents. So you had to be equitable, and you couldn't do selective enforcement beforehand. So I don't know why they added that to the statute, other than to just confirm that what's good for one person has to be good for everybody. And then they put these together some additional specific provisions in the statute to govern very specific things that owners may want to do with their property. One of them, as you point out on your slide, is we can no longer restrict what people want to do on the interior of their homes, as long as it can't be viewed from either the frontage of the property, an adjacent parcel, or an adjacent common area. And similarly, there's some language that they put in last year that they tweaked a little bit this year about people being able to install things in their backyards or side yards, as long as it also can't be viewable from the front, from an adjoining parcel, or from an adjoining common area. So really what this means in a nutshell is, if I'm an owner, in an HOA, I have my own property, I want to put something on my property, it's entirely within my property or within my home, and you can't see it from anywhere. Can't see it from the front, a neighboring property can't see it, can't see it from across the lake on the adjacent common area. If you're a golf course community, can't see it from walking across the fairway on the golf course. If I'm truly enclosed in a way where you can't see what I've done and it's entirely on my property, there's now some language in the HOA statute that's going to protect people from being able to do that, even if there is a guideline or restriction that would otherwise prohibit them from doing what they're doing. I don't think this is as bad on the interior stuff. I mean, what somebody does on the inside of their house, especially in a single family home community where you're not really, bothering neighbors or doing anything that's going to affect the structure of a neighboring unit. I don't know that we care that much about it, but I mean, this is bad law when it comes to people putting things in their backyard. If somebody can store an RV or put up whatever they want to put up in their backyard, if nobody else can see it, I think that could cause some problems for associations moving forward. So we have to be very careful about that when we see what people are trying to do, if it's going to be covered by this new law. And then the other thing to keep in mind, which is a subject of its own webinar, but I'd be remiss if I didn't point it out, is it's also could be affected if you have Kaufman language in your governing documents. That's becoming a big issue. If you have language in your declaration that applies the law as amended from time to time, you're going to have a much harder time combating these new laws, because you've basically said, hey, we're accepting the law as it changes from time to time, so all these new laws are clearly going to affect us. Whereas if you don't have that Kaufman language, and that's language that says that the statute applies as amended from time to time, if that's not in your declaration, you may have a better chance at fighting these laws by being able to say, hey, this law came out after our declaration was in effect. You can't retroactively apply it to us, so we don't have to follow that law. So again, not enough time in this short webinar to really delve into that issue completely, but that is the question that I would be asking your association's attorney is, do we have that language, and how is that going to affect the applicability of some of these new HOA laws to our community?
Yeah, we may have to do a Kaufman language webinar at some point.
Yeah, definitely.
I never thought so many board members would be so well versed in Florida case law,
Yes.
but here we are. One thing that's on this slide, I think that's super important to talk about, is the denial of an application. This is probably the most impactful change from July 1. Could you explain what they've done here?
Well, I mean, the bottom line on denials in 723.035 has always really been the precedent on this for many, many years now, and it's what I rely on all the time. The days of being able to say we don't like it because it doesn't fit with what our community is all about are really over, and it's been over for not just since this past July, but for many, many years. What the statute basically says is, if you're going to turn somebody down for something that they're building on their property, you need to be able to point to some clear objective guideline or criteria that's in your documents, whether it's in your declaration, which would be ideal, or whether it's in your architectural guidelines or rules that were created based on the authority contained in your declaration. Whatever it is, you want to have some clear guideline or objective restriction that you're relying on when you're turning somebody down. To say, well, we just don't like it because it doesn't fit our scheme, I've heard that common scheme argument used before, and we have used it, but that really only works if you're in one of these communities where every house really is truly the same. And to give you an example, my parents live in an HOA community that's basically, they're single family homes, but they're 0 lot line homes. Every villa is the same color paint. Every villa has the same roofing style. Every villa has the same gate that goes from the front of the property to the walkway to your front door. If you're in a community like that where everything legitimately is the exact same color, same style, same material, then I would argue, okay, you've got a true common scheme, and I don't know that you need to have something saying that this is the only type of roof tile allowable, because you have an implied covenant, at least. You know, walking into this community when you moved in, all the homes have the same roof tile. They have the same color, whatever it is. But if you're not in that very limited situation, being able to say, well, no one else has thought of that before, no one else has done that before, it's not really within our scheme, that's just not really going to fly anymore. And so that's, I think, the big take-home lesson for our HOA clients and condo clients. Again, it's less important there, but for whether you're condo or HOA, if you're trying to turn something down, you really need to have something in your governing documents, in your rules, your regulations, your guidelines, that says these are the allowable types of fences, these are the allowable colors of roof tiles, this is what we're going to allow the screens to look like. If you can think of it, put it in your guidelines and give people notice as to what is going to be allowed and what is not going to be allowed, because you're going to have a tough time denying somebody if you don't have an objective guideline or criteria to point to.
Right. So that brings up a really interesting question. A couple people asked a couple of different ways, but now that we have such a specific requirement to cite what we're, what you're violating when we deny the application, what do you do when someone comes up with a, would kind of universally be accepted as unacceptable, but no one's ever thought of it before? I mean, no one ever suggested maybe putting a windmill in the front yard, so we didn't have any windmill rules, but we all agree we don't want to see a 20-foot windmill. So what do we do?
Yeah. That's the tough part. And on those, you're going to have to try to find something, and that's our job as the association's counsel, to find something in your documents that we can hang our hat on. Maybe the nuisance clause, or maybe there is something that just talks about structures in general needing to be approved, or maybe in a situation where it's that just totally egregious. We have to come up with the argument that there is no citation that we can provide because there's just something that's inherently unreasonable about this. I mean, I would tell you maybe 15 years ago or so, I represented an association where somebody wanted to put, I can't make this up, a gravestone in their front yard because the husband had passed away, and he did a lot of work tending their garden, and he passed away, and the wife wanted to put this little stone in the front commemorating him in their garden, and the association wanted to turn them down. And it's one of these catch-22s where it's like, all right, well, no one else has ever done it. We don't have a guideline in place, but we can't have people putting up gravestones in their front yard. So what do you do? And it's a great question, and I don't know that I have the perfect answer for you, but you got to find something. I think we went with the nuisance clause in that situation. But look, I think do your best to try to, if you can't think of windmills, think of statutes or other similar items. Have your attorney wordsmith something so that there's some language to give you some leeway. Having something that says, or similarly situated things or items must be approved or will be prohibited. Give yourself something that you can hang your hat on so you can at least cite to something to give us a puncher's chance.
Right. So I think the short answer is this is what the lawyers are for. So.
Right, exactly.
All right. So I think you did cover this other section. My slides are a little slow here, but yeah, we got into this about, a little bit about what's, if you can see it or not see it. And then that Kaufman language applies to that. There's a whole debate in the law right now about all that. So why don't we kind of jump in, run out of time. So we'll jump into kind of what are the best practices of your committee. So why don't you just talk about the notice requirements, Steve, and I'll get into some of the other practical stuff.
Okay. Well, notice requirements, this is one of the few committees that's required to be open just like a board meeting. So, and that's why I talked earlier about not loving the idea of delegating to one person, because it's kind of awkward to have a notice a meeting and have people show up for one person to sit at a desk and check off and approve or disapprove. But Florida law says that any committee that has the authority to approve or disapprove architectural decisions, it does need to be open. So it's a posted 48 hours notice, just like a board meeting, needs to be open to the membership, just like a board meeting, and you need to have a quorum of that committee. So if it's a 3-member committee, you need to have at least 2 out of the 3 members of that committee present to have a duly called and established meeting.
And then practically, I mean, the minutes are very important. Applications are going to be approved, and let's all be honest, 95% of applications ultimately are approved. Most of them are for pretty straightforward things. Yeah. But for that 5% that you're going to deny, you definitely need to make sure you notice the meeting, and you definitely need to make sure you take minutes at that meeting, because those minutes, should cite the reason for denial, or at a minimum, just cite, denied pending attorney review or something if you need to get your ducks in a row. But you definitely need to have an understanding of what happened at that meeting, because that could be crucial down the line if you do get into a dispute about one of these, unanticipated or unappreciated improvements.
Yeah.
So again, we only had about 30 minutes today, so I want to be respectful of everybody's time, but kind of what's your action plan as a community member? Take stock of your current situation with the new rules being very specific about citing the reason for denial. You may need to enhance your rules. Your current rules may not be sufficient. You may not be having those meetings that you need to have when you're going to be denying an application. Maybe your minutes aren't as thorough as they need to be. After July 1, I definitely would tighten up what you're doing at the HOA level. That means looking at your rules and your governing documents. Make sure, talk to your attorney, understand what rulemaking authority you have. And I would consider updating those rules and regulations if you have concerns about things happening in your community that you don't want to see. Make sure you have clear policies and procedures for, the committee. There's different ways to do that. We talked about meeting and taking minutes, and then most importantly, administer the program that you create consistently. I know there's nothing attorneys hate more than inconsistent enforcement when ultimately they're tasked with having to, really fight an issue in a community. So any other thoughts, Steve?
I mean, I think that really sums it up greatly. I think the take-home lesson is clear, objective guidelines. Again, avoid ambiguity. So whether it's on the substance of things, such as the types of fences or roof tiles that we're going to approve, or it's on the procedures, whether we want to adopt fees, refundable deposits, things like that. You want to put as much as possible in black and white so people know what the rules are going into it. I did see one question, and unfortunately with the half hour, we couldn't get to all the questions, but it just popped up on my screen. Somebody asked, can members of the ARC also be on the finding committee? Again, in theory, I think in theory you can, but I don't love that, because if you have an ARC violation, you might have members of the finding committee sitting in judgment over something that they may have approved or disapproved. So I wouldn't commingle committees like that. And I saw questions about, can the board act as the ARC, depending on the documents again, but in most times it's really up to the association to ultimately to approve. So generally the board can act in the absence of an ARC. So, but I would like to see that language in the documents to make it clear in that event. But I'm sorry we couldn't get to all the questions. But yeah, I mean, final thoughts are to help us, at least when we're prosecuting these types of things, be clear, be objective, and remove any ambiguity, and have your guidelines, your policies, your application pages reviewed by your counsel to make sure you're in good standing, you're compliant with the laws, and there's nothing that needs to be updated.
Right. Thanks. So I put our contact information up here. If anyone would like some additional assistance, either in the management area, with some of the practicality and operation of these things, or in the legal aspects, please don't hesitate to reach out. There are I'm gonna try to give you guys a few more minutes just so we can get to a few of these questions. Jimmy asks about the hurricane protection standards. This was also in the July 1 laws, Steve. So it sounds like associations have to develop some hurricane protection standards. What are you advising people in that regard?
Yeah, I mean, if you're going to try to limit what people can do with whether it's a certain type of style shutter or a certain type of impact window, you need to have standards and guidelines in place so people know what the ground rules are. You can't outright prohibit people from having protection, but you can condition it upon reasonable guidelines. But again, to me, this is sort of superfluous with the legislature, because we always had 720-3035 that said that in order to disapprove, you needed to have that based on objective guidelines and criteria. So to me, that always implied that whatever you're trying to control or disapprove, you need to base it on guidelines. So I think this is a little overkill, but it's basically confirming that even with regard to hurricane protection, shutters, windows, the take-home lesson again is, if I want to make it clear that the community should have a certain style that's going to be approved by our board or by our ARB, let's put it in writing, let's get it in black and white, and here's the type of shutters that we're going to allow, here's the type of impact windows, here's the style we're going to allow, or the color of the film, or whatever it is. Get that in your guidelines, and that way you can have a better chance at moving forward, being able to enforce uniformly in your community.
All right. So I think this is an interesting thing just to clarify. Someone said our architectural committee is developing architectural standards and guidelines, a separate document, separate from the rules and regulations document. Is that acceptable? I'll just speak from my experience. That is a very common practice, that there's an architectural guidelines manual, I'll call it, separate from maybe the association rules. But I think Steve will agree with me, as long as those guidelines were passed in accordance with the way that rules have to be approved. It's just rules by another name. Is that fair, Steve?
100%. It's no different than, let's say you have a set of clubhouse rules, a set of pool rules, whatever. These are just your architectural rules. But yes, you want to call it architectural planning guidelines or criteria, that's fine. It brings up, we didn't really discuss this, but I get the question all the time, do we need to record our architectural guidelines or our rules? And several years ago, the answer to that would have been yes. And the reason for that was the statute used to say that the governing documents, any changes to the governing documents need to be recorded. And the definition of governing documents under HOA law at the time included the rules and regulations. About 3 or 4 years ago, they took that out, and now the rules and regulations are technically not defined as governing documents. So as a technical matter, both for condo and HOA, you don't have to record rules and regulations or architectural guidelines. I like to do it anyway. I think just as a practical matter, because you're putting the world on notice, you're putting it out in the public records that these are what your guidelines are. So somebody can't come around and say, well, I just moved in here, I didn't know. They're supposed to do a title search and see what the recorded documents are. So I still recommend doing it, but it's a good question that I always get. And the technical answer is no, you're not obligated to record them. But again, I still like to do that.
All right. Let's see here. So licensed contractors, can the architectural review committee require licensed contractors?
Yes and no, maybe. And again, that's based on the new statute from July of this year. This goes back to similar to what we talked about what people can do inside their home or in their backyard. There is another statute that came out this July that says that An association cannot limit or restrict a contractor that a individual homeowner wants to bring onto the property simply because they're not licensed. So again, I think the answer to that is going to really come down to Kaufman language again, and again, a topic for a future webinar. But I think there are strong arguments that if you have Kaufman language in your documents, now you subjected yourself to that law, and you won't be able to require somebody having a license. But if you don't have that language and you have something in your guidelines or your rules that require somebody to be a licensed contractor, then I think you'd still be able to enforce that. What's interesting is the statute only talks about not being able to require a licensed contractor, doesn't say anything about insurance. So I still think regardless of Kaufman language, we can have a guideline or a rule that says that a contractor has to have proper insurance. Whether they can be required to have a license, I think that's going to come down to Kaufman language.
All right. Okay. Well, I think we went a little bit over, but I did try to get to as many questions as we could, both in the registration and some of the ones on here today. So I do appreciate everybody's attendance. This was obviously a pretty hot topic. We may need to schedule another one of these, Steve, and maybe
Absolutely.
an hour for it a couple months from now. So we'll talk about that. But thank you everybody for joining us. Really appreciate it. If you want to see future classes that we'll be hosting, both with Sachs and Caplan and other firms, please look at our website, campbellevents.org. That's campbellevents.org. And really appreciate Steve being on. I think you'll see him and me here in the near future again. So Steve, any words before we go?
Appreciate the opportunity as always. Look forward to the next one, and always happy to help. My contact information is there on the screen. So if anybody has any follow-up questions that we didn't get to, I'll be happy to address them.
Very good. Thanks, Steve. Thanks everybody who attended today. Have a great afternoon, guys.
Take care.
Thanks for watching. For more great educational content, click the subscribe button now.